A woman in Alaska is sentenced to an astonishing 120 years in prison for murdering her two young babies. 30-year-old Stephany Bilecki, who was previously known as Stephany LaFountain, pleaded guilty this summer to 2 counts of second-degree murder for the deaths of her 2 daughters, 4-month-old Cheyenne and 13-month-old Jasmine. The babies never got the chance to grow up together. They were murdered 2 years apart from one another. So let's go back to September of 2015, when Bilecki made a startling phone call to her mom and then boyfriend. She told them her 4-month-old daughter Cheyenne was dead, but she didn't call 911 until just 10 minutes before her mom arrived. Officials say 4-month-old Cheyenne was by all accounts a healthy baby girl. However, her cause of death was originally thought to be SIDS, or sudden infant death syndrome. Then the case would eventually take another dark turn. 2 years later, in November of 2017, another horrific death. Bilecki, who at this point was married, tried to call her husband, who was deployed. However, those calls were never answered. So she reached out to her in-laws. She told them 13-month-old Jasmine was not breathing. Once again, as the grandparents rushed to her home, she called 911 just before they arrived, telling them a story similar to what she had said 2 years earlier. But suspicions grew this time around. Then investigators made a shocking discovery. Bilecki made disturbing searches online, including ways to suffocate, drugs that kill people with no trace, can drowning show up in an autopsy report, and 16 steps to kill someone and not get caught. These searches would later be used against her in court. 13-month-old Jasmine's autopsy report was crystal clear. She died from a lack of oxygen consistent with suffocation. That alerted authorities to reopening the case of Cheyenne's death, painting a clear picture. Both of her daughters had been murdered. In August of 2018, 2 years after Cheyenne's death and a year after Jasmine's death, a grand jury indicted Bilecki for murder. It took several years for the case to play out in the courts, but in August of this year, Bilecki copped to the murders of her daughters and pleaded guilty to 2 counts of second-degree murder. At Bilecki's sentencing this week, prosecutors recommended a 65-year sentence for each of the murders, totaling 130 years. The judge ultimately decided on that sentence with a catch. 85 years of that sentence would be suspended, leaving Bilecki to serve a total of 45 years in state prison. For Bilecki, that means she'll be in her 70s before she's eligible for release. The baby's grandmother shared her relief on Facebook, writing in the group, "Justice for Jasmine and Cheyenne. The day has finally come. Tomorrow she'll be sentenced." But for Bilecki's daughters, who would have been 9 and 8 years old, they never had that chance. The gruesome murders shocked the Alaskan community. Former Fairbanks Police Chief Eric Jukes said at the time, "Just think about a mother killing both of her children over 2 years, completely isolated events. What that means, the evil that exists out there." The Fairbanks District Attorney said in a statement the conduct forming the basis of defendant Bilecki's conviction shocked the conscience. He added, "Although we cannot pretend that anything will ever make up for the losses suffered by the fathers of these babies or other family members, I do hope the convictions and sentences imposed afford some measure of justice to the families of Jasmine and Cheyenne and to the Fairbanks community at large." A devastating story. So let's bring on former child abuse and sex crime prosecutor Marian Brachub. Marian, thank you so much for joining me today. This case is really, really horrific. A mom pleads guilty to murdering her 4-month-old and 1-year-old baby. What's your reaction, especially given this happened separately, one murder in 2015 and another one in 2017?
Well, my immediate reaction is just as a mother and as a former prosecutor, for my heart just to go out to these 2 babies and to their families and their survivors, and what a tragic loss, especially one, as you mentioned, that was separated by time, and we can conclude would have involved separate planning instances, which just makes it all the more egregious. But my heart really does also go out to this defendant, believe it or not, because for this to have happened first with one child, and then for a second horrible instance of death and killing to happen a second time, that just tells us that there was really a need for attention, intervention, services, something to have protected this woman from herself, protected these children from her, and nothing happened in the interim, which is a failure of the system.
And in your opinion, how did investigators go from a SIDS death to what was described as a perfectly healthy child, to learning her daughter was murdered by strangulation?
Well, I think that the fact that there was a second child who died so soon after the defendant's first child kind of probably raised some red flags and would have led to a heightened scrutiny and a heightened investigation. And I think that's where the cause of death was determined to be by strangulation or by lack of oxygen to the brain. And that's where the investigators were led to do a little bit more forensic research. And that's, I think, where the defendant's internet searches proved to be very telling and very valuable pieces of evidence had this case proceeded with a prosecution. And as you know, I'm sure the internet searches and her search results revealed that she was actually researching how to commit a murder, how to cause a death without leaving trace evidence, without leaving any indicia that there had been wrongdoing, that there had been foul play.
Yeah, and speaking of those Google searches, ways to kill a human with no proof, drugs that can kill people with no trace, can drowning show up in an autopsy? That really kind of to me says, and possibly as well to you too, that detailed level of planning. I mean, these are truly disturbing searches, especially when we keep in the back of our mind that this was just a young baby. But what are your thoughts overall of just how, while the searches did show a level of planning, but at the same time, if you're trying to get away with something like this also kind of is leading investigators and prosecutors to point the finger directly at you.
Right. Well, it does show, as you mentioned, it does show certainly premeditation. It shows, in my opinion, malice of forethought, meaning that there was this hardness of heart and this wickedness going into, and of course, I'm drawing that language from the case law. That's not my personal opinion, but that was the state of mind going into this crime. This was not something that was a crime of passion or something that was accidental. This was something that was very well researched and well thought out ahead of time. I think that perhaps someone who was planning something like this would not be thinking clearly enough to say, "Gee, I need to cover my tracks and maybe not use a personal internet browser or not use something that is so traceable back to me and back to what my thought process was and back to what my intentions were," which really leads to kind of the mind-boggling nature of a crime like this. She had the presence of mind to do the research for how to actually execute this killing, but not the presence of mind to not make her search history so obvious and findable.
And are you surprised the case didn't go to trial given this kind of, damning evidence by all accounts that kind of could secure a conviction and if the case had gone to trial? But are you surprised that she negotiated a plea deal for this case?
I'm not. I'm not surprised. I mean, as you know, such a high percentage of our cases, both in criminal courts and in civil courts, resolve with non-trial dispositions, and our use of the jury system is really reserved anymore for disputes of fact. I think that the fact that she pled guilty is part of the reason that a portion of her sentence was suspended. That there is a chance that in her older age, when she's in her 70s, that she'll be paroled, that she'll see the light of day again. That was probably on her mind, wanting to have the chance of not dying in prison. But had this case gone to trial, I think that certainly the internet searches had they been established forensically, had they been linked back to the defendant, would have been very, very valuable evidence. But of course, there is always a consideration on both the prosecution's part and the defense part about resolving cases with a non-trial disposition. Prosecution can say, we spared the families having to hear about the gruesome details, the gruesome deaths of these two children, these two babies. We spared the taxpayers and the court system the time and the resources to go through a case that was evidentiarily very strong and perhaps would have ended in a conviction. And on the defense side, there is certainly a self-preservation interest, which is she was facing or could have been facing life in prison times two on both of those sentences, and she did receive a portion of the sentence that was suspended. So that is to her benefit. It is in her interest to have admitted her wrongdoing and take somewhat of a reduced sentence.
Now, you've prosecuted prosecuted cases, excuse me, similar to this one, probably as horrific of details, just like this one. Is there anything that the defense attorneys or even the defendants in these cases are saying as to why they did something like this, especially given that strangulation is such a personal crime? And to do that to your own child, let alone such a young, small child, what are they kind of saying, if they're saying anything about why they did this?
Well, I haven't seen anything from the defense or from the defendant herself personally explaining her rationale or explaining the why she did it. To be perfectly honest, with her guilty plea, she could have allocuted. She could have mentioned something in her own defense as to what her state of mind was, or anything really that she would have wanted the judge to consider in terms of throwing herself at the mercy of the court. I am not aware of any explanation or any allocution that the defendant may have given. The only thing that I can think of from real other unfortunate and really tragic real world examples is that perhaps this was a woman who was suffering from a mental health issue. Perhaps this is someone who was suffering with or trying to overcome postpartum depression, given the age of these children. I read that her partner, her husband, the father of one of the children, had been deployed. So I don't know how much family or social support she had in raising the surviving child before, of course, that child was killed. So I don't know the why or the explanation for it. And with the charge that she pled guilty to, the second degree charge, the rationale wouldn't have been pertinent to pleading guilty. It wasn't that she was asking for a reduced sentence to a lesser homicide or murder charge. So I don't think the why would have come into the judge's consideration.
And she was sentenced to, more than 100 years in prison. But, why sentence to her to that amount only to give her 85 years suspended, meaning she only has to serve 45 years in state prison? Why give her such a high amount only to kind of reduce that to just 45 years?
Well, because then there is always the chance that if she is non-compliant, say she is paroled when she's in her 70s, and she does not abide by the terms of her release, if she does not abide by the terms of her probation, say she absconds, say she is arrested on new charges or commits a new crime, or has contact with a child under 16 one-on-one in a non-public place, that would be a violation of the sentence. And in that case, the sentencing judge, if that judge is still around, still on the bench at the time, that judge would retain jurisdiction to resentence the defendant and give her the remaining time on the sentence that was originally suspended under the original sentence. So there is always a retainer of jurisdiction, so to speak, by the original sentencing judge to add time, or I shouldn't say to add time, to impose the original sentence in its full form if the defendant was non-compliant with the terms of her release, when and if that does happen in 40 or 45 years.
Yeah. And I think, there's always going to be that lingering question of, if she didn't want to be a mother or wasn't even fit to be a mother, why would she go and have another child? Because by all accounts, she almost got away with the first murder, but then she went and had another child as well too. And then, of course, we now know that child had died too, and her mom is responsible for it. What are your thoughts about that? Like, adage though, that, if she didn't want to be a mother, wasn't fit to be a mother, why go on and have another child?
Well, again, unfortunately, I can't climb inside her mind or her heart or her psyche and understand what was happening to her. I can only imagine that this was someone truly disturbed, truly ill, someone truly suffering in their own right. And I can only pray that the souls of those two little children are at peace.
Right. Well, Marion, I want to thank you so much for joining me today. Before we sign you off, though, is there anything else you'd like to add?
I don't think so. I think that these stories are unfortunately far too common, and we hear about violence against children and violence against those who are the most vulnerable victims. And there really does need to be a system in place to make sure that they are protected, that they are cared for, that they are nurtured, and that if there are services that their parents need in order to be the best parent they can be to them, that they are in place and they are made available to parents of all strata of our society.
In addition to Stephany Bilecki's 45-year sentence, she was also ordered to have no unsupervised contact with minors under 16 in non-public locations. Reporting for Law and Crime, I'm Elizabeth Millner.